Friends, this presentation is about the significance of Kesavananda Bharati decision in preserving the rule of law in India and some interesting developments which took place after the decision, including an unsuccessful attempt to review it. No debate on constitutional issues in India is complete without reference to the Kesavananda Bharati case. The decision in this case has preserved the supremacy of the constitution as against the parliamentary sovereignty which the then government sought to establish. This case has imposed restrictions on the amending power of Parliament under Article 368 by propounding the doctrine of basic structure. Since the time when the Constitution was adopted, it was debatable whether the Parliament has the right to amend the key provisions of the Constitution, including fundamental rights, in any manner it wanted. Previous cases of Shankari Prasad and Sajjan Singh gave absolute powers to the Parliament in amending the Constitution, but the Golaknath case held that the Parliament could not amend the fundamental rights, and the amendment under Article 368 is a law within the meaning of Article 13 under the Constitution, and Article 368 merely laid down the procedure for amendment. But Kesavananda Bharati case held that the Indian Parliament can amend or alter any part of the Constitution as long as it does not alter or amend the essential features of the basic structure of the Constitution. The former Attorney General for India, Soli Sorabji, opines that the judgment in Kesavananda Bharati profoundly altered the future of the Indian Republic. In the 13-judge bench, 6 judges upheld Parliament's claim for unlimited power to amend the Constitution in any manner it chose, while 6 other judges held that Parliament's power was limited and it could not alter the basic structure or the essential features of the Constitution. According to Soli Sorabji, the 13th judge, Justice H.R. Khanna, travelled for long distance on the road that upheld Parliament's claim, but at the last moment held that the power of Parliament to amend the Constitution would not include the power to alter its basic structure. This portion of Justice Khanna's judgment, as future events show, saved democracy and prevented India from degenerating into a totalitarian regime or a one-party government. After Supreme Court decided the Kesavananda Bharati case, as I have already told you at the beginning, there were many interesting developments which took place. The government considered the Kesavananda Bharati decision as a stumbling block in its functioning. Enraged by the decision, the government superseded 3 senior most Supreme Court judges who had ruled against the government, and Justice A.N. Ray, who was the 4th in the line of seniority, was appointed as the Chief Justice of India. The superseded judges resigned, and there was a widespread protest throughout the country. In June 1975, Allahabad High Court found Indira Gandhi guilty of 2 corrupt election practices, and she was disqualified for 6 years from contesting elections. The 39th Amendment to the Constitution, passed later by the Parliament at the instance of Indira Gandhi, granted immunity to her against any challenge to her election. 41st Amendment, which lapsed eventually, had granted complete immunity from all civil and criminal proceedings to the President, Vice President, Prime Minister and Governors. Even the 42nd Amendment to the Constitution dealt many body blows to the Constitution. But for the doctrine of basic structure, these amendments would have become valid and would have caused serious damage to constitutional democracy. Indira Gandhi actually appealed to the Supreme Court against her disqualification, and she succeeded in her appeal, but the court struck down a part of the 39th Amendment that prevented the election of a Prime Minister from being challenged. When her appeal was pending before the Supreme Court, The Chief Justice A.N. Ray sprang a surprise on October 20th, 1975 by ordering the constitution of a bench of 13 judges to hear arguments on two questions. One of them was whether or not the basic structure doctrine restricted Parliament's power to amend the constitution. But the real reason was to review the Kesavananda Bharati decision. Soli Sorabji, who was in the team of advocates assisting Palkivala in a Kesavananda Bharati case, opines that this order was indeed surprising because no review petition had been filed by any of the parties to the Kesavananda Bharati case. If at all the Kesavananda Bharati opinion was to be overruled, then it would be necessary to set up a bench of 15 judges. But strangely, a bench consisting of same number as existed in Kesavananda Bharati was constituted. Palkivala in a letter requested Indira Gandhi to withdraw government's attempt to get Kesavananda Bharati judgment reconsidered. Indira Gandhi simply ignored his letter. An excellent account of what happened in the court at the hearing is provided by T.R. Andhya Ruzina and Prashant Bhushan, who are the senior advocates in the Supreme Court, and they were present in the court hall. Very interesting exchange of views took place between Palkivala and the presiding judges. Starting his arguments, Palkivala pointed out that no review petition was filed. He wanted to know from the court as to whether the intended review was based on any oral request made by the Union of India. For this, the Chief Justice said that no request was made by the government, but the petitioners had made the request for review. When Palkivala expressed his doubt about this, Chief Justice said that the request had come from Tamil Nadu government. But Tamil Nadu Advocate General said that he never made the request. Then the Chief Justice Ray said, well, we are all asking for some constitutional amendment to be struck down on the basic structure theory. So the question arose. Palkivala replied that the question would arise whenever a constitutional amendment is to be struck down on that theory, but that does not mean that it should be reviewed. During the course of the hearing, Justice Beg said that he did not know what these basic structures or basic features were. For this, Palkivala said that it was inconceivable that the Supreme Court could not understand its own judgment, then who will? Anybody who reads the judgment carefully can understand clearly and cannot have any doubt about the doctrine. Further, he said, if Article 368 of the Constitution itself said that the basic structure cannot be damaged, would the court have said that it did not understand? Another judge, Justice Murtaja Fazul Ali, tried to justify the review on the ground that the Kesavananda Bharati decision was ambiguous and not clear, and they could clarify and lay down what the basic structure was. Palkivala argued that there was no ambiguity, and if there was any, there is no need for a full court of 13 judges to clarify as to what is basic structure. Attorney General Nirende strongly supported the need for the review of Kesavananda Bharati decision, as the government but also the citizens should know the correct position in law. Several judges asked Nirende whether the basic structure theory had come in the way of passing any socio-economic measures. They could not give any convincing reply to this. The arguments went on for 2 days on 10th and 11th of November 1975, and in the opinion of Soli Sorabji, those 2 days of arguments represented the finest hour of Palkiwala's legal career. On November 12th, 1975, that is the third day, the case was posted for hearing, and as soon as the bench assembled, the Chief Justice announced abruptly the dissolution of the bench. This sudden dissolution of the bench was a total surprise and an anti-climax. Swarabji opines that even to this day it is a mystery as to why a review bench was constituted. The Chief Justice had to face a lot of embarrassment due to his unsuccessful attempt to get the Kesavananda Bharati decision reviewed. Subsequent events have proved that but for the theory of basic structure, the constitution would have been defaced and defiled. The basic structure doctrine has acted as a shield against repeated attempts by the government to subvert the constitution. With this, I conclude this brief presentation. Thank you.